Today's speaker, Mr. McCusker, is going to be joining us in here in just a few moments. I've got a few notes that I want to make sure. I'm not real good at remembering law firm names, so I want to make sure I get this straight. From 69 to 73, he was an associate at the Cravath, Swain, and Moore law firm in New York City. From 73 to 90, the Kutak Rock Omaha partner. He was a partner there from 74 to 1990. And from 1990 to 2008, he was the executive vice president and general counsel with Mutual of Omaha Insurance Company. His most recent position was the executive vice president for business conduct and general counsel for InfoGROUP Incorporated, where he also in 2009 was appointed the secretary. If you don't know much about InfoGROUP, I hope you read our notice that we sent to you. They're the leading provider of data and internet resources that enable targeted sales, effective marketing, and insightful research solutions. They're located in Omaha, Nebraska. Mr. McCusker was a graduate of the economics department here at Notre Dame as an undergraduate, and then went on to law school and graduated from here. One of the more important things about his law school time here, he was ranked #1 in his class when he graduated. He's joined today by his daughters, Emily and Marie. They're sitting over here in the red jackets. Also, his brother Dennis is here, and his nephew Tom, who is a senior in our program. With that, Mr. McCusker.
Thank you, Dean, for the nice introduction and for the warm welcome. I have some stories this morning about corporate misadventures that I'm quite sure you're going to find extremely interesting. There are any number of lessons that spin off of this long series of misadventures that we could talk about, but ultimately we're going to focus on a situation that some of you may encounter. In fact, I suspect in an audience this large, a few of you will encounter during your careers, and that is what you do when you're faced with the prospect of a superior who's engaging in illegal and improper conduct. That's one of the things that we will ultimately want to focus on. But I want to start with a little bit of a background information about InfoGROUP. I know Dean Gallio sent you some information, and some of you may have heard about it. As the holding company, the parent company, is not really very well known, but a number of its subsidiaries have very important activities that touch all of our lives. The email marketing that we all have grown to love, the subsidiary YesMail is a big promoter of that activity. Sales Genie, which you may have heard of, provides marketing leads to all kinds of marketing enterprises. One of the more well-known subsidiaries is Opinion Research Corporation. You probably wouldn't have heard that name, but if you look at opinion surveys as they're reported on the news, such as on CNN, if you look at the bottom of the survey results, you'll note that they were provided by Opinion Research. So it's basically a company with some very good businesses, but unfortunately, what I used to describe as a very colorful history could be more properly described as a rather troublesome history. But they're a key provider of marketing information and a lot of the information that internet search engines use. It's been a very good company for a very long time in terms of its financial results, but as you may have learned from information the Dean sent you or your own readings, it's had recently a very troubled history. InfoGROUP started off for many years as another story of the great American dream come true. It was started by an immigrant in his garage with $100, all of which was borrowed. This was back in the early 70s. The gentleman, the founder, had a brilliant idea that at that time, people who were looking to market to specific segments or types of businesses had no central place to go to get names, addresses, contact information. So he started with a very simple process of going through the yellow pages and organizing information from all over the nation about various types of businesses, which you can appreciate since it wasn't available to marketers at that time. Marketers jumped on it, and it became an extremely successful business. Ultimately, after 15 or 20 years, the business that was started with $100 enjoyed a market capitalization of over $700 million, which is not huge by Wall Street standards, but compared to starting with $100 is pretty significant results. Unfortunately, while the business was run exceptionally well in terms of production of revenue and profits, the founder had some personal failings that caused a great deal of difficulty for himself and several others. He regularly engaged in excessive spending of corporate assets for his personal expenses. Ultimately, the company had to pay a great price for that. He had to pay a great price, and more importantly, other members of the management team, senior officers and directors, who didn't respond to his misspending, all suffered greatly. The company endured enormous expenses for litigation and investigation, the distraction and embarrassment that brings, litigation from shareholders, and a long investigation by the Securities and Exchange Commission. Back in 2008, it was almost exactly 2 years ago now, a shareholder action, as you know, shareholders can sue the corporation on behalf of themselves and the corporation. Shareholders who became aware of his misspending sued the company and him and a number of directors. As a result of the settlement of that lawsuit, the founder, who was at the time the CEO and the chairman of the board, resigned, as did the chief financial officer and the general counsel, all of whom were replaced. Then a new senior management team came in, and the new CEO contacted me to become the new general counsel, which I did. Now, I want to stress, as we're talking about infoGROUP, that it's a very good, solid operating company, and because of changes in management, it has overcome its troubled history and is doing extremely well. So it is not currently a scandal-plagued company. The new management team, which came in about 2 years ago, cleaned up all the messes, settled the lawsuits, resolved matters with the SEC. And recently, actually it was the 1st of July, the company was acquired by CCMP Capital, a major private equity firm, as a result of which the shareholders were paid over $450 million in cash. So the new management team cleaned things up, got the company sold, it's under completely new ownership, and it's doing extremely well. As is common following an acquisition, the buyer replaced the senior management team, so I am no longer associated with infoGROUP. As a lawyer, my professional obligations never expire, so the obligations that I owe the company of confidentiality continue. So everything we're going to talk about today is purely going to be based on those matters which are of public record. Even though it was the founder whose activities started all this difficulty, we're not going to spend a great deal of time talking about his problems and what they might mean to you. But in order to get the background set up so you can appreciate the severe difficulties with which the company had to deal, it will be useful to talk just a little bit about the legal, financial, and reputational problems which he caused himself by misusing corporate assets. What we ultimately want to focus on is what a certain member of the senior management team did, or more properly, failed to do in the face of these difficulties. One way to get a picture of the long-standing abuses of corporate assets by the founder, who was, of course, removed as CEO and chairman of the board, is to recall an article from thestreet.com. They periodically, I think once a week, they run an article called The 5 Dumbest Things on Wall Street. On March 19th of this year, they featured the former founder of InfoGroup, as you can see from this story here. And if pictures are worth 1,000 words, this picture is worth several thousand words. Here he is sitting with a piggy bank with the name InfoGroup on it. Now, I want to read this to you because many of the words are quite precious. The title, InfoGroup's Jet Set CEO. What's the difference between a public company and a piggy bank? Apparently not much if you are InfoGroup's former CEO, Vinod Gupta. Gupta, who also founded the database provider, agreed Monday to pay more than $7.3 million to settle federal regulators' charges. He embezzled nearly $9.5 million from the company to finance a lifestyle that included private jet travel with and without ex-President Clinton, multiple vacation homes, and nearly 24 fancy automobiles. Unsurprisingly, the former jet-setting CEO agreed to the settlement announced by the Securities and Exchange Commission without admitting or denying the agency's allegations, but did agree to refrain from future violations of securities laws. Gupta served as CEO and chairman of the company from 1992 through August 2008, when he resigned to settle a shareholder lawsuit alleging the company misspent millions of dollars on domestic and international air travel for Clinton and his wife, then Senator Hillary Rodham Clinton. Bill Clinton had a 6-year, $3.3 million consulting contract with the company, ostensibly to open doors for Gupta and Omaha, Nebraska-based InfoGroup. Either that, or Bill has mad tech skills we don't know about. According to the SEC's civil lawsuit against Gupta, however, it was Gupta who was constantly opening doors. The door to his private jets, to his 80-foot yacht, to his 5 vacation homes. I think the number's a lot more than 5. To his 28 country clubs, etc. The key to all those doors being shareholder dollars he allegedly sucked from InfoGroup's coffers. Now that Gupta is barred from serving as an officer or director of any public company, it seems that the SEC has finally changed the lock on him. Now, the dumbometer score, I don't think you can see that. That's the rating they give for the activities that merit being included in the 5 dumbest things on Wall Street. The dumbometer score is 75. That's on a scale of 100, which actually seems a little low to me, but continuing, says dumbometer score 75. Says Gupta gave over $1 million to Bill Clinton's presidential library in Arkansas. So if he wants to read up on corporate governance, that's a good place for him to get some peace and quiet. Now, can you imagine the situation of someone who'd started a company from nothing, grew it into a nearly billion-dollar enterprise and then ultimately facing publicity like this, not to mention legal difficulties from the SEC. But again, we're not really here to focus on the founder so much as the difficulties for the company and those people who didn't respond to his misgivings. One thing you can appreciate is that the activities in which he engaged, and we might have gone over it too quickly, but these activities went on for many, many years, at least according to the SEC's judicial positions. They started back in 2003. So these were very long-standing activities that a lot of people at the company had to know about. More importantly, from the corporate perspective, as I'm sure you know from your general understanding of life, or if you had a business law class, or from whatever source, companies who have executives that engage in this type of activities have separate legal and financial responsibility, such that in addition to all the other difficulties which the founder and other members of senior management had, when the new management team showed up near the end of 2008, the company had its own severe difficulties, principally with the SEC, but perhaps with others, because of all these improper activities. As a consequence of that, the company could have faced substantial fines from the SEC, extended litigation, and the risk of being charged with or found liable for civil fraud. Obviously, if a corporation is either charged with or worse, found liable for civil fraud, it will have an enormous negative impact on its business, because every RFP, a request for proposal, that any company sends out, and particularly those that relate to governmental activities, make inquiry about charges or findings to that effect. And if a company has that in its history, then it greatly limits its opportunities and would be a crushing financial result. So one of the very first things the new management team had to focus on was resolving the Securities and Exchange Commission problems in a manner that didn't cripple the company. And that's where the new CEO, the new CFO, and myself spent a great deal of our time. I'm pleased to report to you that while matters didn't end so well with the founder and some others as it related to the SEC, that as far as the company itself, matters with the SEC were resolved on an extremely favorable basis. And I'd just like to give you a snapshot as to what that was all about and how it all came about. The first thing the new management team did was to approach the SEC and not even pretend that we were in a position to contest charges, and to reach out and be willing to cooperate with the SEC in this investigation. One of the things, there's probably a number of you that are thinking about law school, and you all have heard about the lawyer-client privilege. One of the last things a company like this can do when it's faced with a serious governmental investigation is to try and stand on the secrecy that's associated with the lawyer-client privilege, because you're not going to generate any goodwill, and you will generate tons of ill will with the regulator. So we went in, told our story to the SEC about the new independent directors, the new management team, pledged our cooperation, turned over thousands and thousands of pages of documents willingly, and waived the lawyer-client privilege. So that as a result, the company resolved its own problems with the SEC on a very favorable basis, such that the SEC never sued the company, and we resolved it pursuant to and administrative order. And I think it's very instructive that in what I consider to be a highly unusual step, the SEC voluntarily, in its formal order resolving matters with the company, included a rather lengthy paragraph about the reasons it was willing to reach a favorable settlement with the company. And we've now got this up here on the screen, and although it has several elements, I think it's worth reading before we begin to focus on the plight of the former CFO. Quoting from the administrative order, in determining to accept the offer, that is the company's offer to settle with the SEC, the Commission considered remedial acts undertaken by respondent and cooperation afforded the Commission staff. Specifically, Info undertook remedial efforts, including replacing officers and directors, so the founder and the others who were responsible were gone, creating a new position of Executive Vice President for Business Conduct and General Counsel, that was the position that I held, instituting mandatory director and executive officer training programs, hiring an independent compensation consultant to advise on compensation matters, implementing new internal control procedures and policies concerning reimbursement for expenses, perquisites, and related party transactions. Further, Info formed a special litigation committee comprised of independent members of Info's board of directors, which in turn hired independent outside counsel to conduct an internal investigation of Gupta's expenses and related party transactions, and presented the results of the internal investigation to the Commission staff. Moreover, Info dedicated several months to review and analyze certain expenses submitted by the company to the company by Gupta between 2003 and 2007 to determine the amount of undisclosed perquisites paid to Gupta. This effort reduced the time and resources necessary for the Commission staff to conclude the investigation. So, all that was resolved very favorably for the company, and we were obviously quite pleased to have that put behind us, and it was critical to the prospect that the company might be sold on a profitable basis, because it would have been impossible to sell a company with this kind of cloud hanging over it. Now, before we move to the next phase of this, I just thought of the fact that I didn't say at the outset that you're free to ask questions or make comments at any point in time. We'll try and leave some time for the end of that, at the end of our discussion for that. But if there's something that strikes you that you'd like to hear more about or you don't quite understand as we're going along, don't hesitate to interrupt with a question. And one other thing, Dean Gallio mentioned that it's nice when your speaker is a Notre Dame grad to come back with some Notre Dame stories. And I was going to do that at the outset, but I couldn't really think of anything, particularly since my lovely young daughters are in the audience, that I'd want to describe in any great detail. But I will tell you just a little bit of my situation with Notre Dame. I don't want everybody to be jealous, but I did come from a town that you'll all think is one of the greatest in the world, that is South Bend. My dad was actually a professor at Notre Dame, and Dean mentioned it. I've got a nephew, Tom Gorski, who's a senior in the business school. Had siblings go here, and of course my father. And when Tom gets his degree in May, he'll be my 9th niece or nephew to graduate from Notre Dame in recent years. So we've got a lot of tremendous Notre Dame connections, and it's really a great thrill for me and my family for us to be here. Now, what I'd like to get to is to what I consider to be, for an audience of prospective business executives one of the most important lessons from this whole InfoGroup story. What were other members of the executive team doing while all this was going on? It was so extensive, and it lasted for so long, and there were so many elements: cars, planes, country clubs, a honeymoon that wasn't mentioned in here. He was getting good at honeymoons. I think it was his third one that the company paid for, or maybe it was his fourth one, but whatever the case, the knowledge about his activities was quite widespread throughout the company. And what we want to focus on for a few minutes are the responsibilities of corporate officers when they're dealing with these kinds of activities. As you begin your work career, and as you go up the corporate ladder, on kind of a daily basis, you'll mostly think of your responsibilities relating to your direct supervisor, and that's of course the case. But as I'm sure you've heard in other classes, and particularly when you're confronted with corporate wrongdoing, as an employee, you have quite a number of constituencies to whom you're responsible. As in a corporate setting, it includes the owners, the corporation's customers, the regulators of the company, and in the case of a public company, the investors and the Securities and Exchange Commission. And while it's difficult on a daily basis to keep all that in mind as you're plugging ahead and discharging the daily responsibilities of your job, one of the things that you're going to be reminded of as we look at the situation of the former CFO of InfoGroup is that he was either unaware of or more likely unwilling to discharge the responsibilities that he had to a number of different constituencies far beyond the founder, who was then the CEO and chairman of the board. And the consequences to him, and not to mention to his family, of doing that have been rather striking. So keep in mind, as a corporate official, even in the early stages of your career, you have responsibilities to a wide range of constituencies, and you need to keep those in mind, and they need to govern your conduct. Now, as we continue with this discussion about the plight of the former CFO, who is currently a defendant in a civil action by the SEC, we're going to assume some key facts. I'm not going to comment on my personal opinion about the validity of those assumptions. We're just going to assume certain key facts. First, that he knew about these activities. For this amount of money to be spent over this period of time by the CEO when he was the CFO, it would be implausible in most circumstances for him to claim ignorance. And of course, relating to what he knew, that's not the only test. And we're going to mention this a couple of times. Things that he should have known, he is equally responsible for, which means that you're not in a position as an employee to say, well, I didn't really know. If red flags are there, if circumstances regularly present themselves to you that indicate misconduct, the fact that you may have a plausible position that I didn't actually know for sure is not an answer. Your responsibilities as a corporate employee include being certain that as matters come to your attention which raise suspicion, and if they're regular and significant, that you have to do something about them. So we're going to assume that he either knew or should have known. We're also going to assume that he failed to take appropriate action to correct the situation, and that, as a result, he caused the company to file incomplete or misleading reports with the SEC, which means with the investing public. So what do you do if you're in a situation where you're confronted by improper conduct by your superior? There's several steps that you should think appropriate in a circumstance such as this. And the very first step is kind of a private one, is to sit down initially, do some soul searching, focus on what you've seen, what you think it means to you. And as you do that, you have a legitimate self-interest to consider. And your self-interest isn't the next few months' paychecks, your next promotion, or this year's bonus. Your self-interest needs to relate to your career and your reputation. Because even though you personally may have done no wrong, if you're associated with or have some responsibility for corporate misconduct, you can be smeared with it even though personally you may not have profited from or otherwise been guilty of the misconduct yourself. So that you have a lot at risk. And very frankly, if you find yourself in a situation like this, you're in a real bind, and you need to be realistic about assessing the fact that you are in quite a bind. So nobody likes a whistleblower, or as they say on the streets, a snitch, but you may find yourself, by reason of others' misconduct, put in a situation where you may be required to respond to corporate misconduct. So if you think you're in a situation like that, the next step is to find someone, most likely someone unconnected to the company, that you can consult with about this and try and sort out the right thing to do. Likely candidates, for example, would be lawyers or accountants that you know who have significant experience in corporate matters. It could possibly be the case if you have a trusted confidant in senior management or someone else in your chain of command that you can trust, that you can go to them. If that doesn't feel like the right thing, then you need to reach outside. Obviously, confronting the wrongdoer directly is not oftentimes going to be very effective, particularly if the wrongdoing is long-standing and significant, because you're not going to change it. And so you could sit there and think to yourself, when you're in this bind, if I do this, I'm going to get fired. And thinking farther down the road, if I do nothing, I'm probably going to get fired someday, and then I'm really going to be in trouble. That's why I say you're in a tremendous bind if your superior is engaging in wrongdoing. So once you have thought this through and have some source of a resolution, the next thing to do is begin to take action. And the action involves finding someone who has the willingness and authority to help you deal with the problem. Obviously, early in your careers, you're not going to have much corporate authority. Well, I'm sure in an audience as large as this at a university like Notre Dame, we have many future CFOs and CIOs and CEOs. As brilliant as I'm sure you all are, you won't be in those positions in the next few years. But you're going to be part of a team. You'll know somebody. You'll trust somebody. Hopefully somebody in your chain of command can help you. If that's not the case, there's a really rather large group of sources that you can think about approaching to help you in the bind that you find yourself. The list that I have, and others might have additional items, the company's lead lawyer, usually bearing the title General Counsel, is a place to help. A truly independent member of the board of directors can be very helpful. The company's outside law firm would be a source for you, as would be the case with the company's independent auditors. And finally, state or federal regulators could be a great source for you. Now let's talk a few minutes about each one of these. The General Counsel. Now, early in your careers, you're probably not going to have access to the General Counsel, but a strong, authoritative General Counsel is going to respond to communications, which unfortunately can't be anonymous. Like I think of the recent example of the situation, very unfortunate for a lot of people, involving the CEO of Hewlett-Packard, who was just dismissed. I didn't read a great deal about that story, but I did read just enough to see that someone went to the General Counsel, who immediately recognized the wrongdoing that was involved, took it to an independent board member, and the CEO was dismissed, it seems, in a matter of hours, although it was probably longer than that. The General Counsel has professional responsibilities to the company, to regulators, and to the legal profession to respond to a circumstance like this. So that can be a ready place to go. Now, if the General Counsel isn't strong or is under the influence of the wrongdoer, that's not going to be a place to go. An independent director. Directors have a lot of responsibility, but unfortunately, the only information they have about the company generally is that which management provides them. And if wrongdoing of this type is occurring, you can be quite assured that management is not going to flag this to the independent directors. So if you can stand up and be counted, send a letter with the information that you have, and it can't be anonymous, to an independent director, you'll get some response. That's another avenue. An outside law firm can also be helpful, and this would be particularly the case if the General Counsel were not strong, or you have a sense that a lot of people in senior management are given the whole situation the wink-wink because they're afraid of the authority of the wrongdoer. A well-respected law firm, while it may have several people involved in the business of the company who know about what's going on and are unwilling to deal with it, every law firm has a structure of authority, whether it's a presiding partner or some other person in charge, and a formal communication to that person will get some real reaction from a respectable law firm. Same is true with a company's independent auditors. You can be approached in very much the same way. The ultimate hammer is a regulator. This may be a last resort because a lot of things, including perhaps your current job, are going to go up in flames along with a lot of other people's activities, but this is frequently the most effective approach. Now, depending on the nature of the company's business, it could be a federal or state financial regulator, a state attorney general, or in the case of a public company, the SEC. So, now that we've talked about things that you might do, let's focus on the severe costs of doing nothing, which is not just the cowardly way out, it's also extremely short-sighted, and ultimately, it's a doomed course. You're in a bad spot, but you need to do something. And if you don't, you're going to be really inflicting severe damage on your career prospects and your reputation. So let's go back to the long-serving CFO of InfoGroup, who signed financial statements, signed reports with the SEC over this long course of activities that I read to you about from the 5 Dumbest Things on Wall Street. I note again that these matters are currently in dispute in civil litigation between the SEC and the former CFO, so none of this has yet been proved. But the SEC obviously thinks it can prove it, which is why they've filed suit. The misuse of corporate assets didn't ever come to light through actions or announcements or pronouncements by the former CFO. It came to light as a result of the shareholders' litigation and the SEC investigation. So, looking at it from a distance, it's fair to assume that the CFO did nothing to bring these things to public light. Now, we don't know what was in the mind of the former CFO as the founder squandered these corporate assets, or, putting it in the rather strong words of Robert Khuzami, a name you may not know, but he is the national director of the SEC's Division of Enforcement, when they announced the resolution of the case against the founder, while the founder was, quote, treating the company like it was his personal ATM. Those kinds of activities were occurring. The CFO is going to have a heavy burden to suggest that he was unaware or should have been unaware of it. So we wouldn't be surprised to learn that one of the reasons the former CFO didn't want to confront the founder was that he would likely get fired from his high-paying job. That's a natural thing to think about, but it's the wrong thing to guide your ultimate conduct. What, of course, happened is when the SEC did bring action against the former CFO, he did lose his job. Not only did he lose his job, he suffered damage to his reputation, and now he faces a lengthy court battle with the SEC. However great his career prospects may have been, now they're greatly diminished, if not completely vaporized. There's always the possibility that the former CFO could prevail in the SEC's lawsuit. Even if that should be the case, his reputation and thus his future employability will have suffered greatly, and he will have been distracted from his career for possibly as long as 2 years. Civil fraud cases from the SEC take a long time to play out. Finally, depending on the outcome of the SEC's lawsuit, he may be required to repay the company the substantial amounts advanced to him for defense costs. Under Delaware law and the corporate laws of most states, companies are authorized and required when corporate officers and directors are engaged in litigation for activities relating to the company to advance them the funds to fight the very expensive litigation. The difficulties, though, ultimately, depending on the final outcome of that, the company may not be responsible in the end for those finances, and they can recoup all the money, and these matters are extremely expensive. So, depending on the outcome of the SEC matters, this former CFO could face financial ruin by having to repay the company the very substantial sums it has advanced for purposes of funding his lawsuit. So that's the real lesson that I'd like all of us to take away from this today is if you find yourself in this kind of a circumstance, recognize that you're in a bind, think very carefully about some rational approach, and by all means look far beyond the current circumstances of your career, your next promotion, your next bonus. Protect your reputation, do the right thing, and while you'll be in a very difficult circumstance for a short period of time, it's much better than permanent damage to your career. Now, this pretty much concludes the remarks that I wanted to make, which leaves time for questions and comments that we'd be glad to entertain.
Okay, once again, we do have the microphones. If anyone would like to ask a question, please come forward. I'll start this out. You obviously described a very serious situation with InfoGroup. One of the questions that the students might have that hasn't been asked yet, why did you choose to leave Omaha, the insurance company, and go into an organization that had these kinds of troubles? What was the motivation on your part?
Well, that's a really interesting question. The facts are that in the year 2008, I hit age 65, and I'd had a long-standing understanding with the rest of the legal team at Mutual, who I think were fearful that I was going to work until 77 or maybe 87, that I was going to retire at 65 and let a new group of younger lawyers take over. And prior to that time, I'd had no association with InfoGroup. So I was planning on going into a kind of retirement by going to a law firm where I'd spent about half my career in private law practice. And my retirement time was December of 2008. The whole situation with InfoGroup blew up and became public in August of 2008, by which time in a small community like Omaha, where the general counsel of Mutual of Omaha is really a very prominent job, it was well known that I was retiring, so the new CEO started casting around for lawyers because he needed a general counsel who preferably had been at a big and well-respected company. So he contacted me and I said, well, this will be a lot more fun than being of counsel to a law firm for a while. I must say, I was there a total of 17 months. Looking back on it, oftentimes seems more like 17 years, but it was just an odd series of circumstances that this situation presented itself to me, because it wouldn't be a logical, I understand the question, it wouldn't be logical career move to go from a well-esteemed, long-established, stable company like Mutual of Omaha Insurance Company to the place that InfoGroup was in 2008. But I couldn't resist the opportunity to have a chance to clean something up, deal with a little bit of justice, if that's okay for a lawyer to do. And it turned out great because we got the company cleaned up. We got it sold in what was a very favorable transaction. So it turned out extremely well for me.
Other questions? Would you come up to the microphone? We want to record the question.
Hi, my name is Julie Bucher. I have a fast question. You've spoken quite a bit about what to do in the event that we do discover some kind of corporate misconduct.
Yes.
But can you tell us a little bit about the kinds of warning signs we should look for?
Well, it's going to vary greatly. Let's go back and look at the situation of the founder of InfoGroup. If you would observe, and a lot of people observed, the fact that he belonged to 28 country clubs around the world, that he had a fleet of 20-some cars, had 10 homes in various places around the world, and everyone in any position of seniority in the finance and accounting departments had to know that the companies were paying for this. the yacht that had very little corporate activity. The situation with the Clintons is a little bit more mixed because that has a bit of a political spin to it. I suppose people could justify hiring an ex-president as a consultant, but there's a series of kind of practical circumstances. Now, if you had nothing to do with the corporate finances or the accounting records, you would almost assuredly know about his lifestyle. But if you were at all associated with accounts receivable, accounts payables, financial records, you would see the regular payment of these kinds of expenses by the company. Those are the kind of things that are red flags. Now, it was the CFO who was responsible for that whole team of people that knew about it. That's the kind of thing that's a red flag.
Hi, my name is Andrew Charneski. I have a question. At what point do you draw the line between corporate CEOs having excessive pay packages and using corporate funds to live an extravagant lifestyle like this?
Well, from a strictly legal perspective, there's a fairly easy answer. The difficulty for the CFO, and of course for the founder, was not so much that these expenses were excessive and personal, but they were not disclosed as compensation or perquisites. If, as obnoxious as the whole situation would have been, if, say, it was $7 million a year, $10 million a year, it doesn't almost matter what the number is, if the company's financial reports and SEC filings had disclosed that these amounts of personal expenses were paid on behalf of the CEO, then the CFO's position would be relatively safe. It wasn't so much that the amounts were spent and that the kinds of activities most of us would consider kind of obnoxious and excessive. The technical flaw is that they were not disclosed. And of course there's some associated tax issues with that too. But this isn't just about excessive compensation, because that's a completely different issue and would be thought about in many different ways. The fact is that the failure to adequately reflect the nature of these expenditures in the company's financial records and SEC reports is what got everybody in trouble.
Hi, my name is Margaret Kennedy. I'm just wondering, at Notre Dame, there's obviously a very large emphasis on ethics and integrating ethics into our careers and our study and that sort of thing. And so I'm just wondering how the ethics really affected the development of your career. It obviously has played a very important role in the past year or so. And then also how that ethical education was received by the business and law communities at large.
Well, in terms of how I guess it's benefited me in my career, first of all, I feel very good about my career. I don't have anything to hide and I sleep well at night. And I guess another side of that coin is I haven't gotten in trouble for anything. One of the worst things about ethical violations, particularly it seems to me of people that I've observed, somehow people just don't do this once. They get into a pattern of improper conduct and ultimately you're going to get caught. And that's a road to failure for yourself and your family and lots of bad consequences. And I remember, and I was thinking about it, to go to what I thought was the second topic, is how how did I get an impression of all that when I was younger? I kind of remember, and it's sort of easy being a lawyer. I remember my first year of law school, we had a class in ethics. And frankly, I wasn't terribly enthused about it because in a rather immature view that I had at the time, I just wanted to learn really all these hard legal rules about contracts and property and evidence and these more lofty notions of do the right thing didn't seem to be important to me. But as I observed things over the years, I went back and reflected on what we were told and what we were taught in ethics class, and a lot of things made sense to me because, very frankly, I guess I was kind of naive because I didn't really know any lawyers growing up. I was quite shocked very early in my career at seeing the number of lawyers that engage in questionable activities, and by no means a majority of the profession, but you would think a profession that would require so much training and education and has such great potential would attract people that had enough good sense to not do stupid, improper, illegal things. But, and there's lots of great jokes about this, but, you know, a lot of lawyers do a lot of very dumb things. And it's pretty much the same situation kind of that the CFO of InfoGroup was in. You get anchored to your paycheck, to your job, you got to have it, and you're not thinking long term, you're not thinking the right way. And a part of that comes from what you're taught as a student and what you observe as a young person as your career is developing. And you know, the constant theme for me is to think long term. Is I don't want to have a great first 3 years as a lawyer and then get in a whole lot of trouble and have the whole thing go poof on me. So you have there's a very direct connection between your legitimate self-interest for your long-term career and always doing the right thing. Because if you don't, ultimately, someday, it's going to nail you. Is that responsive to your questions? Okay. How are we doing for time, Dean Gallio?
John Hannon.
Boy, these students are looking younger every day.
You make some important points, and first of all, Notre Dame leads Wall Street in the number of CEOs. There's no other university with as many CEOs. There are a lot of CEOs in the crowd today, future CEOs. But there's sort of two nuances that I'm interested in. One is, how much of your response when you encounter unethical or illegal behavior needs to be full bore? Go to the Omaha World Herald with a headline, and how much of it should be a more nuanced response? But secondly, in this case, this was clearly a lot of, there were many legal markers to hang this on. But what if this wasn't so clearly illegal? What if it was simply a matter of ethics and possibly a matter of your interpretation versus others' interpretation as what it was acceptable? How much, you know, if you're senior management, there are other senior management's positions. If you're 5 years out and you got kids to feed and it's a down economy, you put yourself at great risk, no matter what your worry is about 5 or 10 years from now. How do you look at that?
Well, let me respond to the first part, John. Thank you for the question. In terms of going full bore and trying to generate publicity, or however you might respond, it's going to depend so much on what the circumstances are. I would say, you notice it wasn't on my list of sources for resolution. I think the media is wonderful, but you can't really count on them to do exactly what they should do, and they're sometimes irresponsible. But how much you attack the situation is going to vary greatly on the circumstances. For example, if I had been the general counsel of InfoGroup while all this was going on, and I, of course, have had a lot of time to think about this, there would have been no point in my talking to the founder about it, because that conversation would have lasted about 30 seconds, and in consequence of that, I would have been fired. Now, I would have been out of a job, but the battle would just be beginning at that point. But I know exactly what I would have done if I were the general counsel, is I would have gone to the head of the board of directors audit committee, tell him that we had serious problems, he needed to immediately convene a special meeting of the audit committee, and I'd bring the records and confront him with them. Then the board, having greater authority, of course, than the CEO, would take over at that point in time. Now, as a matter of fact, as you could read in other public reports on litigation, InfoGroup's board of directors at that time, going back now 3 or 4 years ago, would have been ineffective in dealing with it, but that would have been my first step. Now, in terms of the second topic you asked about, if there are all degrees of taste and propriety and concerns people have about excessive compensation, but in order for you to get yourself in a situation where you really need to do something because it's the right thing to do and because your career is at risk, I think it's pretty much got to get to the level of illegality. Because if you just don't like something because it's distasteful to you, or you don't think it's the right way to do things, if there isn't some difficulty associated with it, that with the help of a lawyer or an accountant, you can't translate into illegality or impropriety in the financial statements, then the best thing to be doing is to start discreetly looking for another job. Because if it's corporate spending that's properly disclosed that you think is excessive or wasteful, then that's not a circumstance that suggests you're required to do something. There has to be a certain illegality associated with it, simply because you see it as being in bad taste doesn't translate to the kind of difficulty that some of the people who were in the past associated with InfoGroup are now facing.
Thank you very, very much.
Okay, thank you. Thank you.